Igama, lamakhosikazi, malibongwe, namaste. I'm advocate Ayesha Tiry, born in Port Elizabeth, South Africa, residing in Johannesburg. And I am very, very excited to engage with the aspiring arbitrators, aspiring lawyers, aspiring mediators in India. And I commend this initiative of the Alternative Dispute Resolution Oracle from the leading law university, New Law College in Pune. Malibongwe, well done. Thank you so much for inviting me to participate in this wonderful initiative. I am here to address you on arbitration and the impact of the South African Constitution on domestic and international arbitrations. To share just a little bit about myself, I have grandparents that are born in India, 3 of them. So my mom's mom is born in Manipur. My mom's dad is born in Gujarat, and my dad's dad is born in Mahat. I have been to India a few times, the North and South India, and this pendant that I'm wearing is actually bought in South India. So thank you so much for allowing me to participate and to engage with you from a South African perspective on arbitrations. In order to provide context, I believe it's important to understand the South African Constitution and how it was birthed. So South Africa experienced heinous apartheid. So apartheid was an atrocity, human rights violation that was perpetrated on many of us. And fortunately, there was negotiations. These negotiations between the various factions and parties culminated in the South African Constitution. This constitution, thus, is birthed from negotiations. It wasn't through war, it wasn't through litigation, it was negotiated. Now, in the context of alternative dispute resolution, this becomes quite relevant. Because as you know, negotiations is where parties deliberate and come to certain conclusions on their own. If they cannot do this, we have the possibly mediators that can assist and facilitate this agreement, or we can arbitrate, and failing which there's always the recourse to litigation. So if you have regard to this Constitution of South Africa, it is birthed from a resolution that is not mediated, not arbitrated, but negotiated. Now, if you look deeper and you interrogate the values of South Africa, the values of South Africa is encapsulated in Section 1 of the South African Constitution. It expresses that we are a nation and a country that is committed to advancing human rights and freedoms, dignity, and achieving equality. We are committed to the rule of law, constitutional supremacy, and universal adult suffrage. If one has regard to our values, which is in Section 1 of the Constitution of South Africa, Act 108 of 1996. Our Constitution was signed into being the final Constitution in Soweto, Sharpeville, on the 10th of December 1996. Why I'm highlighting this will become apparent because the values of South Africa will permeate in our interpretations, in how we interrogate and how we view alternative dispute resolution as a country, how we view negotiations, mediations, and arbitrations. It is important to bear in mind that the South African Constitution is birthed from alternative dispute resolution, particularly negotiation. In South Africa, we have two dominant statutes that regulate arbitration. The one is the domestic arbitration is regulated by our Arbitration Act of 1965, and we have an International Arbitration Act based on the New York Convention, and we are aligned to the unilateral model law. So South Africa is arbitration friendly. We are mediation friendly. We are negotiation friendly. In order to understand that beyond the South African Constitution and legal text, let's engage with African philosophy. Very important in South Africa is Ubuntu. Ubuntu is a philosophy that encapsulates humanity. It encapsulates the phrase that I am because you are. A person is a person through another person. It is very much about love, caring, feeling. It is about human rights. And Ubuntu is, as I believe, extended, and that extension is through Zenzele, which is Vuk'uzenzele. Stand up and do it for yourself. When we stand up and do it for ourselves, we're actually doing it for everyone, because in African culture there is no I, so we stand up and do it for everyone. If you look back and you look at apartheid, the South African laws were not for African black people and were really oppressive laws. So what happened is that those that were oppressed by the laws stood up and did it for themselves, because the laws of South Africa wasn't doing it and assisting. So Ubuntu is very much recognized by our constitution, by our laws as being part of South African laws. And Ubuntu is very entrenched in restorative justice. It speaks to reconciliation. It speaks to humanity. And I highlight this as this is pertinent in alternative dispute resolution. If you look at mediation, mediation speaks to dignity. The heart of the South African Constitution, the heart of the Bill of Rights, is Section 10 of our Constitution, which is the right to dignity. If one has regard to oppression, to human rights violation, the greatest offense in the apartheid was to the dignity of the oppressed. Blacks in South Africa, our dignity was violated. So we really, with our South African Constitution, look after dignity, human dignity. And we aspire to achieve equality and human rights and freedoms. Now, in the context of arbitration, how does arbitration really fit into this value system? South Africa is friendly to arbitration. I say this because if you look at the way our courts have interpreted prior to the Constitution, since the 19th century, from Roman Dutch law, we've always valued party autonomy. So party autonomy, the will of the parties to resolve their own disputes, has since time immemorial been respected by our courts. Our South African courts will not readily interfere with agreements to arbitrate. They haven't done this prior to the Constitution, and with the birth of the Constitution and the entrenchment of human rights and freedoms, with dignity being encapsulated in our Bill of Rights and our value system encapsulated in Section 1 of the South African Constitution, Act 108 of 1996, we clearly now, with constitutional supremacy as encapsulated in Section 2 of the Constitution, we must adhere and have regard to the constitutional supremacy and our value system as a nation, and that clearly is to advance human rights and freedoms, to protect dignity and the achievement of equality. Our courts have had the opportunity, our highest court in the land, the Constitutional Court of South Africa, has had the opportunity to speak to us on private arbitrations through the Lutendo Mphaphuli judgment in 2009. In Section 34 of the South African Constitution, we have entrenched the human right to access courts for a justiciable dispute. Everyone that has a dispute that can be resolved through the application of the law has the right to a fair and public hearing before a court, an independent and impartial court, or another independent and impartial forum and tribunal. This human right is entrenched in Section 34 of the South African Constitution. In Lutendo Mphaphuli, the 2009 Constitutional Court decision, the court had an opportunity to speak to us about how private arbitrations are engaged, if at all, and how this private arbitration is linked with Section 34 of the South African Constitution. So the court then grappled and came to the conclusion that Section 34 of the South African Constitution has no direct application to private arbitrations. It came to this conclusion for particular reasons and on a clear reading of Section 34. As I indicated, Section 34 of the Constitution speaks to fair and public hearings. And the court was not going to be creative and find that a public hearing is linked to private arbitrations. This is the majority judgment. The minority judgment had a different approach, but let's speak to the majority judgment. So, private arbitrations are chosen by the parties because arbitrations, you have the choice for the entire hearing to be private. You have so much choice in arbitrations, and yet in Section 34, this is a public hearing. It's a right to a public hearing. It is fair and is before our courts. So the court was unable to find a direct application for this entrenched human right. Section 34, we must understand, is important for the rule of law. Every nation that or the South African nation, it has an obligation. The government has an obligation to ensure that there is order. This is achieved through the rule of law, and so it has an obligation to provide courts, to provide forums that are public and fair, so that citizens with justiciable disputes can approach these courts or forums to resolve the dispute. So because I'm a citizen of South Africa, I have the right to access this court, and it must be public, and there must be fairness, there must be impartiality, and there must be independence. So the nation, South African government, they provide these forums by mere virtue that it is their obligation. And I have this entrenched right. Everyone that has a justiciable dispute in South Africa has this entrenched right. Now, what do we make of arbitrations, private arbitrations? So the Mphaphuli 2009 Constitutional Court decision finds no direct application to Section 34 to private arbitration. I prefer the terminology of the majority justices because it is clearly said that they don't enjoy or they question the terminology of whether you say that we are waiving a human right. And I tend to agree with that because the waiver of a human right perhaps is not waiver. Waiver is a commercial concept. It is a concept in our private law when we waive rights. So to speak of waiver may not be the right correct terminology in human rights. So the court indicated this and mentioned that we may not be waiver. Let's stay away from the word waiver. It may not be the right terminology. So I agree, and I would say that we don't waive with private arbitrations. It's not a waiver of a constitutional right. It is more the fact that this constitutional right of Section 34 is not directly applicable to private arbitrations. And this is so because private arbitrations, what is the purpose of a private arbitration? The purpose of arbitrations is speed, its efficiency, its fairness, flexibility, and finality. So if one has regard to private arbitrations, consent dominates. So the parties choose most likely private forums. They choose the arbitrator. They choose the process. They choose the law. The parties choose the area where the arbitration will be held. There is a lot of choice, and this is so much aligned to the value system of the South Africa, which is encapsulated in Section 1, of the South African Constitution, where we value human rights and freedoms. We value dignity. We value the achievement of equality, the rule of law, constitutional supremacy, universal adult suffrage. So private arbitrations is very much in line with who we are as a nation. Our courts will not readily interfere with private arbitrations and the findings of an arbitrator. We now have the Mphaphuli 2009 Constitutional Court decision to look to for guidance on how our courts in South Africa will deal with private arbitrations. And in this Mphaphuli judgment, the courts also had the opportunity to deal with an investigative arbitration. And our court said that we should not simply accept that an arbitration is adversarial. An arbitration can be investigative, and informal. So in this Mphaphuli situation, It was a service contract, a contract by a subcontractor. And this was an informal investigative process by a quantity surveyor who acted as the arbitrator. So this speaks to choice of process. Now, what is also quite interesting is that we have fairness in arbitration, which will be linked to context. So the fairness, it can be expressly excluded, but we need to bear in mind that if you exclude some element that is fair, is this against public policy? Now, this all comes into relevance through when can our courts in South Africa set aside a domestic arbitration or set aside an international arbitration. So domestic arbitrations are regulated by the Arbitration Act of 1965. That sets out clear parameters and for when the court can interfere with domestic arbitrations. And that is if there's misconduct by the arbitrator or the umpire, if there is gross irregularity, and also if this arbitration award was improperly obtained. Now, the case law will amplify the meaning of how it understands these particular interpretations of the misconduct, the improperly obtained, and gross irregularity that may cause an arbitration award to be set aside through the Domestic Arbitration Act of 1965. What is important to note is that any arbitration award that offends public policy, whether it is domestic or international, our courts will interfere with that. It is also important to bear in mind that when the courts will interfere with through the Domestic Act, it will interpret it strictly. So misconduct, gross irregularity, improperly obtained will be interpreted quite strictly. Public policy, how will our courts ascertain if this arbitration award offends public policy? It will assess public policy through our constitutional values. Hence, when I commenced addressing you, I highlighted Section 1 and our values as a nation and Ubuntu. And Section 1 speaks to the rule of law, constitutional supremacy, universal adult suffrage, and importantly, dignity, the achievement of equality, and the advancement of human rights and freedoms. So as a nation, we as South Africa work towards actualizing human rights and freedoms. We work towards dignity. We work towards the achievement of equality. Our South African Constitution is a transformative constitution. It is a constitution that when we interpret the text of the Constitution, we interpret it purposively in line with where we are headed as a nation. So when we are interrogating public policy, and if this particular provision in any arbitration award offends public policy, we will look to the values of the South African Constitution, constitutional values, which include Ubuntu, which include our concept of reconciliation. It also will include the spirit purport and object of the Bill of Rights. We will look to what the spirit is, the purport and object of the Bill of Rights. So all this will inform our interrogation of public policy. And if any term or any award offends who we are as a nation, then yes, our courts will defend the Constitution and defend who we are as a nation and set aside that particular arbitration award, whether it is domestic or international. Bear in mind that our courts will respect party autonomy. We are, as South Africa, we certainly respect human rights and freedoms, and we are transformative. So we interpret in such a way that we want to advance human rights and freedoms. Fairness is natural justice. It is something that we aspire towards. And I would still say that what is interesting is that, yes, fairness is, in arbitrations, will be context related. So you need to ascertain, is this in an investigative arbitration? Is it an informal arbitration? Is it a formal arbitration? So what is fair in that situation? So in a court context, that has a different connotation. It has a different set of interpretation. So it will really depend on the circumstances. And I would comfortably indicate that arbitrations, we don't particularly link it to Section 34, access to courts, and we link it to indirectly through constitutional values, through the Bill of Rights, and how we interpret the spirit, purport, and object of the Bill of Rights. And I would say that I'm very privileged to engage with you, to share with you my understanding of how we as South Africa engage with arbitrations, mediations, negotiations, and everything that I've stated to you now. Bring it into the context of how the South African Constitution has been birthed. We come from an oppressive apartheid regime with heinous human rights violations, where we weren't equal. The laws did not see us as equal. The laws created indignity. So what we want to do and what we are striving to do and what our Constitution does, it creates this fabric upon which to build so that we can actualize dignity, equality, and freedoms for all. We also are very linked to the international space. So we want to, and we are commercially friendly. We are aligned. We defeated apartheid because we had international support, because we had domestic support. So there was assistance worldwide from, and we appreciate that. So what we also do is we want to acknowledge that and that there is the need for commercial engagement between South Africa and other countries. So in order to achieve this, we are aligned. So if our courts need to enforce the arbitration award, then we will respect party autonomy. We respect the sanctity of the independence of those individuals that have come together to create and arbitrate or negotiate or mediate. So if you have an arbitrated award, you have lightened the load on the South African courts. You have said that do not use these resources take these resources, allow the South African courts to use the resources for all the matters that are there. And you have lightened that load. So we will appreciate that and take that process of arbitration, which is chosen. The arbitrator is chosen, the court, the process is chosen, the area is chosen, the law is chosen. So in order to facilitate the speed that business requires, the speed, the efficiency, whatever those parties have chosen, the courts will then enforce that award with the might of our laws and in compliance with our subscription to the international laws. So thank you so much. It is really a privilege to engage with you. I will hope that we will continue these engagements. And Igama, lamakhosikazi, malibongwe. It is one of the many South African languages, Xhosa, which means, and let the name of woman be praised. Vuk'uzenzele, stand up and do it for yourself. And Ubuntu, I am because you are. Namaste. Thank you so much.
I, Shivangi Sinha, Assistant Professor and Faculty Coordinator of Madhyasthta ADR Cell, on behalf of Bharati Vidyapeeth, deemed to be University New Law College, Pune, and Dr. Ujjwala Bindale Ma'am, Dean and In Charge Principal, extend my heartfelt gratitude to Ayesha Ma'am for such an insightful session. Ma'am, we look forward to your guidance and contribution in our future endeavors too. Thank you so much.